Welcome everyone to Brico Property Pulse. We are back like we never left. My name is Mungana Elijah, the business developer, Brico Homes. Today, we are privileged to have an opportunity to host one of our own, our in-house counsel, to share to us more on various sectors. So, Madam Caro, welcome.
Thank you so much. Thank you for having me. It's an honor for that.
Sure.
Let's dive in.
And also, we are very grateful for allowing not anyone can be willing to come and share his or expertise knowledge willingly. We are really grateful. So in real estate, in like 2 to 3 years, people have been having fear due to being sold air. People have been taken light and center, various companies coming in, going out, without mentioning, and people have come fear. So that's why, as Brico Homes, we have decided to enlighten people by this platform on the process. So even if an individual might not be going directly via Brico Homes, but he can understand the process of from now buying, getting to the field, going to the wakili, now you are here, going to something that they call the board. So I think that's where you come in. You can enlighten us on from the word go process. When you like that process, you know you are being taken another vague maybe way. Maybe that's maybe the core goal that you want our audience there to understand.
So thank you so much. Yes, let's dive in. So in any land transaction, the first process is usually negotiation between the vendor and the purchaser. What happens in this? This is where now they will discuss where the land is, the price of the property, and agree on other details, like for instance, the agency that the agent who brought the client to the purchaser, to the seller, who is the vendor. This is where all these terms will be agreed upon. Once there is an agreement between the parties, the second step is usually visiting the ground, which we call a site visit. This is very important because this is where you go and look at the land at face value without anything, just to make sure that you love the land and where it is. Because there is no point of going to the land and yet you've not agreed on the pricing and all that.
Sure.
And also you've not agreed on the commission that the agent, for instance, if you're using an agent, will get in the whole transaction.
Sure.
So after now the site visit, that's where now the parties will come to an advocate for an agreement. So this is what we call in law giving instructions to an advocate. So an advocate will first do their due diligence. They will still have to go back to the land and identify whether the beacons are in place. And secondly, whether the land is of mercantile quality. What does this mean? Is it in a forest? Is it in a water body, what we call riparian land? Thirdly, is it in a wildlife kind of setup? These are the things that an advocate will be able to identify, because if it falls in those 3 categories, this means that this is public land, and public land is not having a merchantability quality, because it cannot be passed on between individuals. Secondly, is it community land? Because process of acquiring community land is also different. There ought to be consent among all the members of this community. Thirdly, is it private land? If it's private land, you need to understand, is it leasehold? Is it freehold? Because the process of acquiring freehold property is different from how you acquire leasehold property. What do I mean in this? Because even the processes of consent, acquisition, and also doing your due diligence is different. Because one is public, quote unquote, but privatized. The other one is fully private land. So we need to understand all these things, and that's why using an advocate is very essential.
Sure.
Thirdly, so once the advocate visits the land, the third thing is giving instructions to a surveyor. What is the role of a surveyor? We call them geospatial engineers.
Sure.
Because it's for them to identify whether the map is corresponding to what is on the ground. Because you might have land that has different coordinates from what you have on the map. So for you to ascertain all that, it's for a surveyor to visit the ground and also make sure that the beacons that the advocate was able to find out, they are in the right place based on the maps that are in the survey of Kenya.
Sure.
So it's very important for every professional to be given their mandate, because if you give an advocate the role of checking out the maps, that's a wrong deal.
Sure.
Because that's not their work. Their work is to make sure that the laws are followed, but for a surveyor or a geospatial engineer, their work is to look at whether the coordinates are appropriate and are relating to what is in the map. So after that, now that's why now we go to the registry and do a search.
Maybe before we get to the registry, so the surveyor is the one supposed to ascertain maybe the square feet, the square meters.
Wonderful.
Maybe the beaconing is incorrect. Maybe the measurement, maybe 9 meters road, or that, where there's bypasses. So that's the work of the surveyor.
Yes. That's the role of the surveyor, you're right. Yes, because as an advocate, I wouldn't know the measurements of the land, whether they're accurate.
Sure.
Secondly, I wouldn't tell whether the size of the road or the path is accurate. My work is just to make sure that there is a path, because in law, that's what you call easements. Easements come forming part of the land, but I can't really tell indeed whether the measurements are correlating to what the map is talking about.
Sure.
So that's why I said it's good to use the right professional for the right assignment. Yes.
Is the surveyor's money included in now the wakili side, or the client has to pay now another amount of money for the surveyor?
That's true. These are two different assignments.
Sure.
When it comes to a surveyor, that's a different assignment, and they charge differently from how advocates charge.
Sure.
Yes.
So for the whole package, so maybe the owner, out of the 10% of the surveyor, of the wakili, now the owner has to add some extra amount now for the surveyor to ascertain now the nini.
Yes.
Okay.
You're right.
Okay.
You're right.
I thought that's a point that you should qualify for the sake of our audience.
No. There is not a single time that we commingle. We are different, and the amount I charge, my fee note is different from a surveyor's.
Sure.
It's also different from a valuer, because also there are times where I advise my clients to look for a valuer to estimate whether the price that they are getting the parcel of land is equivalent to the market value of the property. Also, if, for instance, the client is comfortable using a valuer, it means that they will still have to cough some other amount of money to cater for the fee note of a valuer.
Sure.
Yes, they are all separate entities. Yes.
I think that's one of the reasons maybe sometimes people fear, because there's a wakili fee, there's a surveyor fee, there's a valuer fee. But from our previous conversation, I think it's very essential for an individual, before he or she purchases the land, to consult those expertise on those fees for the sake of not losing out the whole amount.
That's true.
After
you're right.
After the process where we engage the surveyor, now we get to the next step now.
The next step is, as an individual, the next step I do is an official search. This is what we do in the registries. For instance, if you're purchasing land in Kamakins, you will do an official search in the registry of Ruiru. What does this mean? We're just wanting to know whether indeed this land is in the name of the vendor who is the seller.
Sure.
Secondly, once the official search is out, I will now go and do a historical search, what we call in common terms a green card search, whereby now I'll be able to get the whole history of this parcel of land from the point where it was acquired by the first person until now. How has it been transferred? What does this help? It helps us understand whether this land is under succession, or rather it's a is an estate of the deceased.
Sure.
Because most people out here, they are dependents of a deceased, and they will come sell land to a third party even before succession is done. That is called intermeddling of the property. That's an offense. Secondly, there could be collusion of parties whereby now you can acquire land. It's not your property, but you might think because the other party might not know, you go and get a title, a fictitious title.
Sure.
This is when now you'll be able to find out all that information because now it will be clearly outlined how has this land been transferred from one individual to the other individual.
Sure.
Yes, and if, for instance, I find out that the vendor is not giving me the right information based on the historical search, my job is only one, to advise the client to look for another parcel. Because there is no point of telling the client to just trust them, because this is not a matter of trust. It's a matter of truth. Tell us the truth. How is this parcel looking like? How has it been transferred to you? Because without all that information being correct and authentic, it means that this land, you're not very sure whether you'll acquire a clean title, what we call bona fide ownership. Yes.
So now you have to advise now to cut the deal.
Yes.
What about the charges? And I heard you.
About?
What about the charges? The charges, since you started the process and maybe I did the deposit, now on the wakili side, and you have advised me as a client, no, we can't do this, it's a claim. How about the charges? Now the charges.
That's a good question. What we do as advocates, we will tell you our charges. However, we don't take the amount lump sum. We do it in phases. Once we do due diligence, there is an amount I will charge.
Sure.
Once I do a historical search, there is an amount I will charge. Once I go on the ground, there is an amount I will charge.
Sure.
So it doesn't mean that if I'm charging, for instance, 100,000, it doesn't mean that you will have paid me the entire 100,000.
Sure.
So it means that until where the process will end, that's the amount of money I'll have received. Yes.
So now from there, now we go to the search where we were before, now we diverted. So can an individual do the search, or it has to go by the wakili?
Oh, that's a good question. Yes, anybody can do a search. An official search is open to all individuals. Even a historical search is open to all individuals. The only hindrance between an advocate and now other individuals, or rather non-advocates, is that for a non-advocate, you have to go and seek a court order. You tell us, why do you need this search? But for us, we just need our practicing license. That gives us a leverage over now other individuals, because if you're not an advocate, you'll have to go through the entire process of court.
Sure.
Yes.
So instead of me going by the whole entire process and you know how our Kenya things are done, so I think I'll go by the wakili.
Yes.
Or after the search?
After the search, the next thing we do, once we identify that the title is authentic by going to the DCI Land Fraud Department, they're the ones who will authenticate for you that indeed this title is original. Because so many things happen and some titles are not original. They look so original, but they're not. They even have the seal and all that. But when they go to the DCI Land Fraud Department, you realize it's not original.
Sure.
The second thing is I make sure that I do an IPRS check for the person who is selling land to my client. This one will help me be sure that I'm dealing with a legally recognized individual in our laws, because there are people who will come with fake IDs. How will you be able to identify all this? It's only through doing an IPRS check, which is done at the NSSF building. The other thing is, after all that is done, I have gone to the ground, I've done a search, I have authenticated everything is good. The next thing is doing an agreement, what we call a sale agreement. This is very important because if it's done by an advocate, it's legally binding. However, if it's done out there, it might not be legally binding because you might not have all the clauses that make an agreement legally binding. Because whenever you're looking at aspects of an agreement, you have to look at it holistically. because you need to look at whether the people have capacity to get into an agreement. Do people have, is there a meeting of minds? Because if there is no meeting of minds, it means that this agreement is not legally binding. Because if it is done under duress or people are forced to do an agreement,
Sure.
there is no meeting of the minds. The other thing is capacity, whereby we look at, is this person sane? Are they of the right age? Because anyone below 18 years, they cannot get into an agreement. The much they can do is get into an agreement through a friend or a guardian. So those are the things that we need to look at.
Okay.
Yes.
So after an agreement,
After an agreement, now it's done. Now there is a deposit of 10%, which is done by the purchaser to the seller. Ordinarily, what happens is the amount of money is deposited in an advocate's account, which we call an escrow account, which is governed by the laws of LSK, whereby this 10%, what it will help us with is to give us time to make sure that we do the survey of the land. We will be able to get consent. For instance, if it's a freehold property, we'll have to go through the Land Control Board consent. And consent is twofold. There is a special board and there is a normal board. But as an individual, or rather as an advocate, I advise clients to go for a normal board because it gives you so much assurance that indeed you're getting land that is authorized. Because you see, when you do a special board, you're going to the land officer or the land administration officer and just getting a consent. But this other one, you're going before a whole panel of village elders and also the DCC, the county assistant commissioner, and also the land administration officer. So you're able to be sure that the consent you're getting is legitimate, and it will be very difficult to be questioned at a later time. So I advise people to go for the normal board. However, it's really time consuming because you have to be there presently, but it gives you assurance that you're getting the right thing. The other thing after that, now, once the consent is out, there is still another amount of money that will be deposited to the escrow account so that now we can go through the transfer process because it's through the amount being put there that will enable an advocate do the transfer. What is a transfer? This is where you fill forms, the transfer forms in triplicate. You give out your ID, your KRA PIN, so that it's put in the register.
Sure.
Now the name of the previous owner is deleted, and now you're put in as the rightful owner of the property.
Sure.
So this is done at the stage of transfer. This is where now we ask for what we call completion documents. So upon the completion documents being submitted and transfer forms being filled and all that, now that's when now the whole amount is deposited in the advocate's account so that now the title is processed and now the title is out. So the purchaser gets their clean title and the vendor gets the money.
If I may, let me take you back a little bit. There's an account that you keep on mentioning that was supposed to be deposited 10%, then after the agreement amount. Whose account is that one?
It's an advocate's account. We call it advocate client's account. This one is regulated by LSK such that if, for instance, a client needs money, their money when time comes and the client has already taken the money, you can go for a disciplinary at the LSK or something or a department we call Advocates Complaints Commission, which has a tribunal which will investigate this conduct of the advocates. Yes.
What about the broker, the so-called the broker?
Yes.
Are they recognized or according to the law? Because you find each and every time you go to purchase something, find there's someone in between, maybe there's someone that connected the seller and the buyer. Are they recognized or how should we, because you find sometimes they take a lot of amount, maybe from the buyer or from the seller, you find that they are getting 5%, 10%. Are they recognized or how should people handle them?
It's important for people to understand that these people known as brokers, there is a law that is supposed to regulate them. In law, we call them estate agents. There is a law, so they are only recognized in law if they are registered by that body. So even when you're doing transactions, it's important to ask them whether they're registered, because if they're not registered, you really don't have a recourse against them. Yes, but if they are registered, you have a recourse against them in the body of estate agents. Yeah.
And if I may, what the maximum amount of time that can take now from the word go, from the meet of the client, going to the site, writing the agreement, getting the consent, now to getting the title. Maybe the estimated duration time that can take now from the wakili side or from the whole process, so that someone does not be misled, like going to take a year and it's supposed to take maybe 2 to 3 months. Maybe you can elaborate, because we have various real estate companies giving titles at different time frames. Maybe you can maybe elaborate and emphasize maybe what the maybe estimate time, maybe according to the regions or the counties, maybe.
That's a good question. According to, or rather, the laws of land are regulated by the LSK Conditions of Sale 2015 edition. According to that law, any transaction, land transaction, should take at least 90 days. Those are 3 months. Anything that is going above, you need an explanation, a good explanation from the advocate to understand what are these barriers and at least give you constant communication. But ordinarily, a land transaction should take 3 months. That one caters in the entire process from the point of due diligence to the point of completion of the sale. Yes.
So, if I may, the search and the agreement are between now the advocate has to do the search and the agreement. What about the title transfer? Now getting the name to be deleted and the new name to be inserted. And question number 2, how many people can they be inserted their names on the title? Maybe it's a group or a family. Maybe how many people?
Thank you so much for that question. When it comes to the transfer of land, it's not necessarily that an advocate should do the process.
Sure.
Because even surveyors do it.
Sure.
Yes. When it comes to the transfer, it's not really limited to only advocates. Anybody can do it.
Sure.
The other question is how many people can be put in the title. There is no number of limit of number of people, because if, for instance, if it's a succession property, all the dependents have to be put in the property. So it depends on the agreement between the parties, because there are people who will say, let these people be our representatives. But all that information ought to be encrypted within the registry. Only that the title, maybe it will have maybe the representatives.
Okay.
Yes.
So you have touched matters on succession, and in Kenya we have this problem of people having dispute, brothers and sisters. If at all one individual among the siblings is not in unison with the others, can he or she hinder the others from maybe selling the land or subdividing the land?
Yeah, that's true. That's a very good question. Because succession matters are not ordinary matters. They're not handled like any other matter that you can just override the consent of one. If, for instance, one person comes up with an objection, that has to be respected. Yes.
Okay.
Yes.
So, for example, there are some case scenario where you hear maybe the parent said, the grandfather said this land should not be subdivided, or someone, the firstborn has to take maybe the 90% of the land. Is it legal to respect what was said by maybe the father or the mother, or according to the legal terms, each and every siblings have to get the equal share?
That's a good question. But we need to come and talk about succession separately, because it's a whole wide topic.
Sure.
But let me answer you in a very simple way, because the new laws of the Law of Succession Act, it provides that sharing of estates should be done equally according to the number of units, not number of families, not number of wives, number of units. What does this mean? For instance, if your family has 10 children, a wife, and maybe another family of 4 children and another wife, that means that this family has 16 units, 16 people in this family. And that does not end there. How many grandchildren are there? How many? You need to go through the whole lineage, and all of them should be catered for. Equally. Yes. Nobody in this new law, or rather in this new dispensation of the law of succession, even women inherit their heirs